You know, it's always good if you can learn from other people's mistakes. So guess what? Today, class is in session. And if you're new here, I'm Professor Jonathan Noble, divorce and family law attorney. At least I'm going to be professor today. There was a case in Pennsylvania that was filed February 28th, 2023. I'll put a link to it in the show notes. Orsani v. Orsani. It's a prenup divorce case. And I've been talking about prenups here for 2 or 3 years since I've been uploading YouTube videos. And I know that there's other experienced divorce and family law attorney. Shout out to the lead attorney if you haven't seen his channel. He's a very, very smart lawyer. And he talks about prenups too. He says that prenups are enforceable. I'm saying prenups are enforceable. So for the naysayers out there, now, you got to know the law in your jurisdiction. I think he might be in Georgia. I'm in Pennsylvania, New Jersey. Prenups are definitely enforceable, all right? If you follow the statute, if you follow the procedure, if you follow the law of your jurisdiction. Now, I also did a video with a top-tier divorce and family law attorney in Vancouver, British Columbia, Ari Ramelli. And, you know, in a place like British Columbia and many of the provinces in Canada, the judge has discretion to set them aside or modify them. Where in a place like Pennsylvania, they're treated like a contract under contract law. But let me get to the point of this video. I'm not sure how long it's going to run because there's so many great teaching moments in this case that I want to share them through the lens of a divorce lawyer, all right? So here's the basic fact pattern. A guy gets married in August of 2004, and the day before the wedding, he picks up his bride-to-be and drives her to his lawyer's office so she could sign a prenuptial agreement. You know, in law school and on the bar exam, there's a concept known as issue spotting, where you get the more issues you can spot and deal with in a very high-pressure time situation on these exams, the higher grade you're going to get. Issue spotting, right? So when I read this case, I'm thinking, wow, page after page after page of issues. And I want to share this because you need to know it if you're thinking about getting married or your friends are thinking about getting married, whatever. Anyway, getting back to the fact pattern. Husband and wife were married on August 21st, 2004. The day prior, the parties entered into a prenuptial agreement wherein wife relinquished her rights to alimony, all of his assets, including property acquired during the marriage. So what's the first issue? They got into a prenuptial agreement the day before the wedding. Huge issue. Why? Because in most jurisdictions, you need to give the other person plenty of time to find their own counsel. All right? You can agree to waive the ability to get a lawyer, but it wasn't in his prenup. And I would never recommend that if at all possible. Let the other side get their own lawyer. And don't give them the prenup the day before the wedding. It sounds like he probably did it like at the rehearsal dinner. I can assure you that almost 100% of the time, it's going to get set aside if you hand somebody a prenup. All right? At the rehearsal dinner, it's not going to work. Either do it the right way or do it the wrong way and have a false sense that you're protected, because you're not. I will tell you that I do receive probably one call a month and maybe more in April, May, June, July, and August, where someone will call me and say, Mr. Noble, I'm getting married this weekend, and I want a prenuptial agreement because the woman I'm marrying, I'm seeing behaviors that I didn't see before, or she wants to move her family into our home, or you name it. And I'll tell them, I'm sorry, I can't write your prenup because it's not going to get upheld. Well, Mr. Noble, I'll pay you whatever you want. I'll pay you triple your normal fee to write my prenup. And again, no, I'm not going to write it because it's not going to get upheld. Well, then I'll get another lawyer to write it, at which point I'll tell them, I don't know any qualified lawyers that would say to you, okay, I'll write a prenup for you and you're getting married in a week. Unless they have no assets and it's the most basic agreement and she would still have to get her own lawyer, don't do that to yourself. So going back to this case, they signed a prenup the day before the wedding. It's going to get thrown out. Now, if this guy went to a lawyer and asked him to draft a prenup a couple days before the wedding, the lawyer might have said, oh, yeah, sure, I'll do it. Or he may have given him a boilerplate prenup. But most lawyers who do this kind of work, who are on the up and up, are going to tell you it's too late. All right? It's the way it goes, especially if you want it to be upheld. So he gets married in 2004. In 2019, wife files for divorce. What a surprise, right? And then she files a motion to have the prenup set aside. Most of the testimony during this process, now again, she files for divorce and then she files a motion because the court has to decide, is this divorce going to go forward with the prenup intact or not? That's a threshold issue, okay? Because if the prenup is going to be upheld, then the division of marital assets is going to be based on what's in the prenup. But if it's going to get set aside as the wife wants it to be, then it goes through normal equitable distribution. So much of the testimony surrounded wife's affair during their lengthy engagement and husband's decision to seek a prenuptial agreement as a result. So they're trying to convince the court why the prenup should either be set aside or upheld, and much of the testimony is around her affair during their lengthy engagement. Issue. Yep. I don't know who's watching this, but if you're engaged to somebody for a long period of time and she's had a lengthy affair during your engagement, why are you marrying this person? Like, let's call this another side effect or collateral problem with having one-itis, right? If someone's cheating on you during the engagement and you marry them, you kind of get what you deserve, in my opinion. Just my opinion. Okay. Both parties testified that the wife first saw the actual prenuptial agreement the day before the wedding. Issue. How could you give somebody an agreement that important the day before the wedding? They both agreed. They testified to that. She was not afforded any opportunity to seek the advice of counsel. Issue. It's going to get set aside. So if you're thinking about getting married, don't do this. It's going to get set aside almost universally. All right? The counsel for husband made no reference in the prenup of wife waiving counsel. So if he had a clause in there that said, wife waives the opportunity to seek counsel of her own choosing, maybe there'd be a thread possibly that the prenup would get upheld, but the lawyer didn't do that. Issue. Not a lot of lawyers write prenups. So if you get a general practitioner who doesn't really know what they're doing, and maybe this guy went to see originally a family and divorce attorney who does write prenups, and he was told, you're wasting your money. And he went from lawyer to lawyer to lawyer until he found one who was willing to do what he wanted him to do. That could be the case too. I'm telling you, as an experienced divorce attorney, I like to get the prenups wrapped up, meaning completely negotiated and signed by both parties and counsel for both parties in front of a notary before the wedding invitations are ordered or any plans are made. Because I've seen cases where someone will come in and say, no, we get along fine, there's not going to be a problem. And inevitably, almost 100% of the times, there's some issue, right? And it's not the kind of thing where you want to make wedding plans, pay deposits, have people buy airline tickets in from out of town, and the document's not signed yet, because there'll be more and more and more pressure as the wedding day approaches. So to make a long story short, he files an appeal and he raises 8 issues on appeal. And as someone who handles appeals, I can tell you that if you're throwing the kitchen sink at appellate judges, usually it's a panel of 3 judges, at least at the intermediate appellate level, they're already saying, like, why should we believe you? Why should we agree with what you're saying that the lower court got it right? And you want to limit your issues on appeal. So his putting 8 issues in is a huge issue. Right when I saw that, you're entitled to a fair trial, but you're not entitled to a perfect one. So if you start throwing kitchen sink issues, as I call them, at an appellate court, you're shooting yourself in the foot. You're weighing down the good issues that could reverse the decision. So unless there's some exceptional situation, which is very, very rare, I typically like to limit the issues to 3. Sometimes 2, maybe a single issue. Once in a big blue moon, 4, but 8 issues, you're sending a signal that this is a Hail Mary appeal, all right? Unless it's a death penalty case, all right, where somebody's life is at stake. But 8 issues, when I saw that, I'm like, wow. And when I read the issues, red flag. He was asking the appellate court to weigh the credibility of the witnesses, which an appellate court, at least in the jurisdictions I'm familiar with, can't reweigh credibility. Why? Because they haven't seen the witnesses in person. They don't know how they're speaking. They only have a cold record. So not to prolong this, but just to give you that cautionary tale, a lot of people respond to my videos and other videos I've seen by creators that say, well, you know, why get a prenup? Because the other person who signs it is going to say they're under duress. And in the jurisdictions I'm familiar with, and definitely Pennsylvania, it's very rare to have a prenup set aside because of duress. There's only one case, and it was an extreme duress situation. So there are plenty of cases in Pennsylvania where the wife will try to have the prenup set aside, and by saying, it was the day before the wedding, or I was under too much pressure, or the wedding plans were made. The courts won't use that or allow them to use it because why? She could always say, I'm not getting married to you then, if you're going to make me sign this, and she could call off the wedding. So to make a long story even longer, the court found that the main reason why the prenup in this case could be set aside was because her inability to consult an attorney and have plenty of time to get an attorney of her own choosing. So what's the point of this long video? Either don't get married if you want to protect your assets, or if you want to get a prenup, make sure that it's drafted properly with plenty of time before the wedding, because they almost always get negotiated. All right? That's all I got for you. Share this with somebody who seems to think that prenups can't be upheld. They can be, but as this case illustrates, they have to be done the right way. All right? Thanks for hanging in there for this video. Drop a like, comment, subscribe. Love to have you as part of the community. And be careful out there. I'm going to drop a link to this case, Orsani v. Orsani, February 28th, 2023. Superior Court of Pennsylvania.